Lessee of Ashton v. Ashton, 1 U.S. 4, 1760, is a decision of a Pennsylvania Provincial Court, issued when Pennsylvania was still an English colony. It is among the first decisions that appear in the first volume of United States Reports. Colonial and early state court cases in the United States Reports. None of the decisions appearing in the first volume and most of the second volume of the United States Reports are actually decisions of the United States Supreme Court. Instead, they are decisions from various Pennsylvania courts, dating from the colonial period and the first decade after independence. Alexander Dallas, a Philadelphia, Pennsylvania lawyer and journalist, had been in the business of reporting these cases for newspapers and periodicals. He subsequently began compiling his case reports in a bound volume, which he called Reports of Cases Ruled and Adjudged in the Courts of Pennsylvania, before and since the Revolution. This would come to be known as the first volume of Dallas Reports. When the United States Supreme Court, along with the rest of the new federal government, moved in 1791 to the nation's temporary capital in Philadelphia, Dallas was appointed the Supreme Court's first unofficial and unpaid Supreme Court reporter. Court reporters in that age received no salary, but were expected to profit from the publication and sale of their compiled decisions. Dallas continued to collect and publish Pennsylvania decisions in a second volume of his reports, and when the Supreme Court began hearing cases, he added those cases to his reports, starting towards the end of the second volume, 2 Dallas Reports. Dallas would go on to publish a total of 4 volumes of decisions during his tenure as reporter. In 1874, the U.S. government created the United States Reports, and numbered the volumes previously published privately as part of that series, starting from the first volume of Dallas Reports. The 4 volumes Dallas published were retitled Volumes 1 to 4 of United States Reports. As a result, the complete citation to Lessee of Ashton v. Ashton is 1 U.S. 4, 1 Dallas 4, 1760. The decision. According to Dallas's annotations, an unknown party known only as the devisor, the maker of a will by which real property is given as a gift after death, made a will by which he devised real estate to the first heir male of is when he shall arrive to the age of 21 years, so long as that first male heir of is paid the sum of £40 to each of is's daughters, designated A and B. When the devisor died, is only had the 2 daughters. Some time later, is had a son, who reached the age of 21 years and paid his 2 sisters their £40 each. The issue before the court was whether the son of is could take under the devisor's will. Dallas reported that the defendant made 3 arguments. First, since the son of is did not exist either at the time the will was made, or at the time of the devisor's death, the son could not take under the will. Second, even if the devise might be construed as a future devise, the interest was too remote under the rule that a future interest must take effect within the lifetime of a life in being at the time of the devisor's death, or within 9 months thereafter, in the event of an unborn heir. Moreover, even if one of is's daughters or granddaughters or an even later female descendant bore a son, who might arguably become is's male heir, that heir could not inherit under the rule against perpetuities. The third argument was that, since is was apparently still alive, he could have no heir under the legal maxim nemo est heirs viventis. No one is the heir of a living person. The plaintiff responded by arguing, first that this was not a present devise, because the devisor would have known at the time he made his will that is did not at that time have a male heir. Second, the contingency, that is would have a son that reached the age of 21 and paid his 2 sisters their £40 each, was not too remote for purposes of the rule against perpetuities, because it was clear that the devisor intended that the first son of is take, not some more distant descendant, and that the devisor's intent should be respected. The court ruled that the devisor's clear intent was that first son of is should take, and that his intentions should be enforced. It is not clear from the record of the decision or from Dallas's annotations what relationship the devisor or is or the son of is had to either Ashton or Ashton's lessee, the parties to the proceeding before the court. Precedential effect. Over a century after Lessee of Ashton v. Ashton, or as it is sometimes cited, Ashton v. Ashton, was decided, the Pennsylvania Supreme Court would cite it as precedent for the proposition that the word heirs means children in the case of appeal of Porter 45 Pa 201, 1863.
Please subscribe and thanks for watching.